Hello, everyone, and welcome to Uncivil Law. To increase your legal knowledge, please remember to subscribe to the channel. It helps us grow. For today's case, we are dealing with yet another case of COVID restrictions. This is coming out of the state of Ohio in the case of the Monclova Christian Academy versus the Toledo-Lucas County Health Department. In this case, yet another state has put in place COVID restrictions that more strictly target religious institutions rather than conventional institutions. And once again, the courts have to explain to them for a little bit that churches and religious institutions do actually have special protection. They are in fact special. They are mentioned in the First Amendment explicitly. So they do get a bit of special treatment as a result. So we're going to explain to them again that churches are a thing and they have to respect that. Let's get started with this. On November the 25th of 2020, the defendant in this case, the Toledo-Lucas County Health Department, issued a resolution closing every school in the county, public, private, and, more to the point here, parochial, which is religious, for grades 7 through 12, because there can be non-religious private schools, that's why they make a point of mentioning it, for grades 7 through 12, effective as of December the 4th of 2020. The shutdown's purpose was to slow the spread of COVID-19. 14 days to flatten the curve, man. 14 days. This has been the longest 14 days of my life, is all I have to say, man. The shutdown's purpose was to slow the spread of COVID-19. Yet, in the same county, gyms, tanning salons, office buildings, and a large casino remain open. So not so much the parochial schools, but the casinos. Got to get that gambling going on. Hey, the COVID doesn't like gambling. It turns out that COVID has a gambling addiction problem, and so it tries to steer clear of the casinos lest it gets swept up again from its prior history. It's in a recovering stage of Gamblers Anonymous here. Yeah, it turns out that COVID has its 6-month chip from Gamblers Anonymous, and as a result will never enter a casino ever again. So people can go to casinos in complete safety, I guess, or something like that. Let's read some more. By way of background, no one disputes that before the December 4th shutdown, plaintiff schools employed strict social distancing and hygiene standards, which includes the use of a thermal temperature scanner and plexiglass dividers, along with spacing desks at least 6 feet apart, and a mandate that everyone wear a mask at all times. So the school wasn't acting all willy-nilly. They were trying to have the restrictions that people remain. So they were using social distancing, they were using scanners, they were using plexiglass, and they were using masks. So masks and social distancing, but we have to shut them down for some reason, despite all that. Moreover, as the department itself stated in its resolution closing the schools, little in-school transmission has been documented. That does seem to be true as best as I can tell, of all schools everywhere. As best as I can determine, I don't know if anyone's had a confirmed case from schools. If there are, it's got to be low. The transmission in schools doesn't seem to be really a problem, as best as I'm able to determine. Unlike, the nursing homes, which have remained open this whole time, right? But the department closed all the schools in its jurisdiction anyway, on the ground that community spread conditions continue to work in Lucas County. So even though there's no threat here, or we're just going to close them down for some reason, we considered 4 factors when deciding whether to grant an injunction pending appeal. So this is a preliminary injunction request. This 4-part standard should seem familiar. Whether the applicant is likely to succeed on the merits, whether the applicant will be irreparably harmed absent the injunction, whether the injunction will injure the other party, and whether it favors the public interest. This should sound very familiar. This is the 4-part standard for injunctions. Yep. The free exercise clause protects religious observers against unequal treatment. To that end, a law burdening religious practice that is not neutral and not of general application must undergo the most rigorous of scrutiny. Here, the department suggests the resolution's closure of the plaintiff schools does not burden their religious practice at all. Because the resolution provides that schools may open to hold religious educational classes or religious ceremonies. It's a parochial school. They're all religious education practices to some degree. That's kind of the point. Yet they closed them anyway. Okay, that doesn't make sense. Whether conduct is analogous or comparable for purposes of this rule does not depend on whether the religious and secular conduct involves similar forms of activity. Instead, comparability is measured in the interests the state offers in support of the restrictions on conduct. Specifically, the comparability depends on whether the secular conduct engages these interests in similar or a greater degree than religious conduct does. So when we're measuring this, we don't look to whether or not the activity is similar. We look to whether the interest the government is trying to regulate in is similar. That's the basis of the comparison. We therefore consider whether the resolution here treats the plan of schools less favorably than it does at comparable secular facilities. That question is whether we may consider only the secular actors, namely other schools, regulated by the specific provision here, in determining whether the plan of schools are treated less favorably than comparable secular actors are. We find no support for the proposition in relevant Supreme Court case law. The Free Exercise Clause, as noted above, protects religious observers against unequal treatment. So, one of the things that we're trying to deal with here is what is a fair comparator for the religious schools, the parochial schools. What is the fair comparator or comparators? Because there might be more than one. And so one of the questions or one of the ideas was, and especially from the government, is what you should compare that to is other schools. This is a religious school, but it's a school. You should compare it to other schools and see if we're treating it worse. And we're not, because we closed all the schools, because I don't know why, but we did. So therefore, this school has not been harmed more than religion. And the court here says, well, that's not exactly right. We are not necessarily limited to just schools. We can see other things that it's comparable to. Because again, it's not the similarity of the action, it's the similarity of the interest. So the interest in closing schools versus the interest in other things, and where that interest makes sense in an equal protection sense. That inquiry leads directly to the conclusion that the resolution's restrictions are not of general applicability. In Lucas County, the plaintiff schools are closed, while gyms, tanning salons, office buildings, and Hollywood Casino remains open. Hollywood Casino, no COVID threat there. The Cuomo case made clear that these secular facilities are comparable for the purpose of spreading COVID-19, which, why wouldn't they be? Unless COVID acts differently in a gambling casino or a tanning salon versus like a church or something. So, does COVID recognize the ancient right of sanctuary? Or maybe like a reverse sanctuary in this case. So like in traditional medieval sanctuary, the church is the place that the state can't get you. But this is like the reverse of that, because it's the one place that COVID can get you, but it can't get you in the casino. So this is like reverse sanctuary or capitalism sanctuary. How's this working? Are we going medieval France here? What's the deal, man? I don't know. But yeah, maybe the COVID recognizes some reverse sanctuary thing. I don't know. The department offers one final argument to the contrary, that under Ohio law, the department lacks authority to close facilities other than schools. What? The department itself acknowledges that it's a political subdivision whose authority is delegated to it by the state. Yeah, indeed, under Ohio law, the department is a state agency that acts as the administrative arm of the Department of Health. And the Ohio Department of Health has chosen to leave open the secular facilities described above because, I don't know, COVID doesn't like those places. Measured against state restrictions as a whole, therefore, the resolution's restrictions are not of general applicability. The department's closure of planned schools is thus subject to strict scrutiny. The plaintiff's motion for the injunction pending appeal is granted. The Toledo-Lucas County Health Department is enjoined, during the pendency of the appeal, from enforcing the resolution respecting the closure of the parochial schools or otherwise prohibiting in-person attendance at these schools. Thus, that brings us to the end of the case on Monclova Christian Academy versus Toledo-Lucas County Health Department. In this case, the County Health Department decided that they want to have some COVID restrictions. And then they said, well, schools can't open, but gyms can, and casinos and, businesses, but not schools. Schools are bad, very, very bad. And the school says, we were abiding social distancing. We had plexiglass, and we had social distancing, and we had mandatory masks, and all that stuff. And the health department doesn't actually disagree with any of that. It says, yeah, you did all those things, but it's not enough. And the school says, but wait, I thought social distancing plus masks is what you guys have been saying all along. It's like, yeah, but we decided that we want to close the schools anyway. We decided it isn't enough. Wait, what are the rules here? What? So yeah, the court looks at this and is like, yeah, this doesn't make any sense. It doesn't make any sense why you're treating the schools this way when what your stated interest is, we'd like to stop the coronavirus very much. So your stated interest is, we'd like to stop the coronavirus very much, but not in these places where lots of people meet for some reason. Yeah. So the Sixth Circuit says this doesn't make any sense. You can't stop the schools from closing. And that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.